Dear colleagues, we start working day in the Ukrainian Crisis Media Center, and our first press conference is devoted to the topic changes to the law on courts and status of judges, vision of administrative justice judges. We have Mykhailo Smokovych, we have Natalia Blazhivska, judge of the High Administrative Court of Ukraine, and Bogdan Sanin, judge of the Kyiv District Administrative Court and vice president of the NGO, Association of Administrative Judges. And Mr. Oleksandr Paseniuk, president of NGO, Association of Administrative Justice Judges, will speak first. Dear journalists and dear colleagues, I will start from the very beginning. Classically, in the theory of law, there are three types of responsibilities: the criminal one, the administrative one, and civil responsibility. Actually, everybody is able to understand what is the criminal justice as for the is quite clear to people. As to the administrative justice, not everybody is so much clear. As of today, the sphere of responsibility of the administrative judges is related to the administrative sphere, like minor hooliganing, etc. But this in the theory of the administrative law has changed in the latest times. Actually, they had been being developed from mid-19th century. The first ideas about administrative judges, administrative justice were made in early 20th century. Thus, Petros Stolypin, famous prime minister of Tsar Russia, in course of administrative reform, had created first administrative courts which reviewed cases against the authorities, against the governmental bodies. Unfortunately, that reform was not implemented fully because Stolypin was assassinated, and unfortunately, due to this non-implementation of the administrative reform, the state remained under-reformed, underdeveloped, and I believe that full implementation of that reform might allow Tsarist Russia and Ukraine as a part of it to develop differently without revolutions and shocks. Nevertheless, later, after, just before the October Revolution, there was an attempt to create such courts which would review the complaints and claims of citizens against governmental bodies. After revolution, in times of Hetman Skoropadsky, there were attempts to establish administrative courts. Then in Directoria times, under Stepan Petlura, there were issued several decisions about establishment of the Cassation Court. In 1927, the first administrative code was published in Ukraine, issued in Ukraine. This was the only one administrative code of the Soviet Union which provided for rules for relations between ordinary citizens and the governmental bodies. Unfortunately, Stalin's regime later destroyed that code, and only in course of independence, only in times of independence, when Ukraine gained its independence, we made again an attempt to establish the rules of the game in relations between ordinary citizens and the governmental bodies. And by that moment, we came to the point of rethinking the relations between the state and citizens, and understood that the rule of law should protect citizens from discretion of the authorities. The Constitution of 1996 provides that the citizens can appeal to court in case of violation of their rights by authorities and the government. But unfortunately, only in the law of from 2001, the new law about system of justice established administrative courts, and later the courts of appeal were established, and the in the Supreme Court the administrative chamber was established, so-called the secondary cassation. Later, the administrative code was passed. Before the administrative code, there were some orders of the president, and there were not so many administrative cases. When in 2005, when we started to review the administrative cases which arrived to the Supreme Court, we had found that there were almost 10,000 of different cases, customs, taxes, other administrative issues. Unfortunately, this was too much for that number of judges that we had. Unfortunately, again, the authorities did not wish to strengthen the administrative courts, because from the Soviet times we inherited the idea that the governmental bodies acted in favor of the citizens. The administrative code was passed after fourth reading in Verkhovna Rada, and later it was vetoed by President Yushchenko, because the lawyers of the presidential administration believed that presidential decrees could not be vetoed. When administrative justice started to operate finally, and the authorities had seen that many cases were resolved in favor of the claimants, they started adopted to counteract to the provisions of the administrative code, and even the verdict made, the verdict confronting the presidential decree was believed to be an act of sabotage. And now, when we discuss the law on justice, on system of justice, we see clearly that the secondary cassation was preserved. And by the way, the administrative courts should preserve their autonomy. The administrative courts act in line with the special rules and the rule of law, the principle of disposition when the court go beyond the circumstances of the state, and also presumption of guilty for the state authorities. These are main principles of the administrative justice. I believe that after first 10 years of the administrative courts functioning, more than 10 million administrative cases were reviewed, despite the fact that media keep saying that the citizens do not trust the administrative courts. But 10 million of cases were reviewed, and the majority of them were resolved in favor of the claimants and of ordinary citizens. I believe that the administrative courts would continue to protect the interests of ordinary people. Natalia Blazhivska. Dear colleagues, welcome to our briefing of the Association of Administrative Courts of Ukraine. I would like to describe the importance of cooperation of the administrative courts with international courts. Public figures should think about future generations while politicians think about future elections. That's why the drivers of societal development should be professionals who approach to their everyday work not from the point of view whether I will gain additional electorate and voters for the elections, but who really base their actions on the benefit for society. The reforms should be not based on slogans. They should lay the foundation for European values, keeping in mind a long-term perspective. This is specifically true about the reform of justice system, system reform, judiciary reform is not about the judges. It is designed and intended for all citizens, because at any moment of our lives we can become either claimants or defenders or third party involved in the court proceedings. Although the objective of the state should be to decrease the chances for ordinary people to go to courts to seek for justice. The relations between courts and citizens appear when people believe that their rights were violated by by authorities before this fact. So when we come to judiciary reform, we clearly insist that it should be based on the rule of law, not in theory, but in reality. The quality of court decisions should be the basis for this reform. And when the court decision is made, it obligatory should be implemented. With this intention, the advisory board of the European judges underscores the important role of judges in preparation of all the legislation which would regulate their work. The Advisory Board of European Judges many times wrote that when judiciary is under threat, it should defend its rights. And today, let us try to understand whether all those questions, which are quite often asked by media, whether they are unique in global dimension. The Ukrainian mass media say that they are unique, but that's not true. Everywhere in the world, quite often society poses the question whether we should dismiss all the judges or to remain them. Similar situation was in Austria, by the way. We were surprised when we heard that. Unfortunately, this information is not widespread, and this information becomes available only when the associations of judges cooperate with each other. And it is possible to get such information only when we establish good relations between associations, national associations of administrative judges in Europe. I wish to say that in civilized countries they have separate administrative justice, and they have professional associations of the judges of administrative courts. It is very important for all administrative courts in Europe to have similar standards of this justice, develop unified approaches to proceedings, and in terms of European standards of guarantees for judges, in cooperation with European associations, we have very fruitful discussions, and professional associations of administrative judges in Europe have very fruitful discussions with representatives of authorities. Recently, we had the conference, European Justice, the Ways for Development. We stated that we support the course of reform taken by Ukraine, but our big mission should make the most active the newly passed norms. That's why our association, jointly with our international partners, yesterday held a large-scale conference. Administrative judges achievements and prospects. It became a venue for exchange of experiences, how to improve active legislation, the legislation which will come to force by the end of this month, in order to allow it to comply with the highest standards of unprejudiced court and independence of judges. We also should remember about the guarantees for judges. Early in my presentation, I mentioned that independent court, it's not a precondition, it's not the luxury, it's a precondition for the fair court. And we had the story with the judges, five-year judges, who had passed all the procedures, but one state body do not appoint these judges into position. Quite often we have academic discussions about the purposefulness of any court instance. But European partners say that liquidation of the courts should not cancel the provision about eternity of the judge positions. That's why we have developed a set of recommendations, and it's my pleasure to give the floor about this to Mr. Sanin, who will present specific suggestions of our association about implementation of the legislation which would allow courts to be fair and transparent. Thank you for this opportunity.
I will continue, and I will focus on the issues and our proposals to the law on judges and courts. And in July this year, by order of the head of the commission, we created a special commission, and there are different specialists, and our association also joined, and this group was headed by Smokovych, Mykhailo Ivanovich, and accordingly we've worked on constructive changes that were included, the issues that are really important for modern judicial system. We reviewed the changes, practical changes that should be introduced, because we saw that there are problems in judiciary system that needs to be met, and we should take into account different internal and external factors that influence that system. And by our joint effort, we worked on these changes for 2 months, and we got wide proposals, and we created a draft law that we presented at the conference yesterday. And now our colleagues discuss this draft law, and I would like to focus on the factors and the main criteria we propose, and the issues that are the most discussed now in the judiciary. Our main proposals. This is the autonomy not in the framework of Supreme Court, but the autonomous separate court that is independent from the Supreme Court. We see recommendations and consultations and the results of Venice Commission, and they believe that this judiciary should be autonomous, and this element is really important. In such a case, the court will be able to objectively and independently take decisions that will fully defend the interests of each citizen. And our proposal, we took all the factors in consideration to regulate the position that is adopted in the Constitution, that the Supreme Court is the highest court. And we propose such a model. In order to regulate some judiciary, we should have ad hoc courts. And there will be 4 judges. And the main vote is belongs to the head of Supreme Court, and thus we can resolve some conflicts. And what we propose in order to decrease the influence of courts and defend courts from internal and external influences. The first message is that we ask not to limit the number of judges because of lack of financing, as it is proposed by legislation that is envisaged now. Why? We all understand that financing should not depend, the activity of the court should not depend on financing. Courts were not financed 100%. They always had some problems with financing and with some stationery, and also with facilities, and hypothetically there can be some limit in staff because of lack of financing, but the situation can appear that the citizen won't have proper court hearing because judges are lacking. So we should improve the guarantees of social security for judges. Firstly, if judge transferred to another court, he or she should be provided with housing, and also there should be a secretary who will work with this judge. Of course, some judges can be transferred, but in such situation, a judge should understand where he goes to, and there shouldn't be any problems with housing and means. And what we recommend, there should be access of judges to professions, to adjacent professions. The judge is the highest profession in the field, and we know that abroad that judges, they come from different legal areas, and this is for them the highest position, and the judge was a profession that should be properly financed and guaranteed, and they should have been properly trained, and they should have access to advocacy and to other fields of judiciary.